Continuing from video 1, in the opposing view, proponents of activism argue that the federal government itself has not been content to stay within the boundaries of its enumerated powers as they are specified in the Constitution, and that the proliferation of the federal government's reach into all areas of criminal and civil law through the expansive interpretation of the Commerce Clause requires greater judicial checks. Furthermore, there are limits to judicial power, including impeachment, confirmation, congressional definition of appellate powers, and the power to override a Supreme Court opinion through the constitutional amendment. Now, the Warren Court was called activist or liberal because it recognized a whole range of civil liberties and due process rights for the groups that had been previously and historically disenfranchised. The source of such rights was found in an expansive reading of the Constitution and based on the idea of fundamental liberties, those freedoms and protections that the framers would have recognized if they had been asked. Now, central to this view is the idea of natural rights. Recall that the natural law ethical systems talked about in Chapter 2 holds that there are natural laws of ethics that humans may or may not discover. Several of the authors of the Bill of Rights were natural law theorists. Thus, taken out of the context of their time, they would probably recognize that humans have the following rights: the right to be free, to be treated equal to other groups, to be able to make decisions about personal matters without governmental interference, to be free from torture and punishment that degrade the human spirit, to have some protections against state powers. And then in addition, there may be recognition that humans also have rights to basic necessities to survive and to avail themselves of opportunities to better themselves. The first set of rights leads to less government, while the second set leads to more government. That is why the political term conservative and liberal are not strictly comparable to strict constructionist and interpretationist, and why there is such confusion when these terms are being used to describe judicial and political appointees and elected officials. The liberals argue that if the Warren Court hadn't interpreted the Constitution to recognize civil rights, blacks would still be eating at separate lunch counters. Constructionists, however, argue that if interpretationists had their way, government and the courts would be involved in every decision from birth to death. The Supreme Court activism has been intimately tied to who has been on the bench at any given time. The era of activism occurred because of a shift in the membership of the court. Brown versus Board of Education, which held that separate but equal schools were unconstitutional, is considered to be a fundamental shift in social equality or an overreaching decision that had no legal support, depending on whether one is a constructionist or interpretationist. Now, more recently, the Supreme Court has been moved back toward a constructionist stance because of the confirmation of justices like John Roberts, Samuel Alito, Clarence Thomas, and Antonio Scalia, who are constructionists. In recent holdings, the court has upheld federal anti-abortion laws, cut back on free speech rights of public school students, and strictly enforced procedural requirements for bringing and appealing cases, and also limited school districts' ability to use racially conscious measures to achieve or preserve integration. One can predict case decisions based on the justices' ideologies, with Scalia, Thomas, and Roberts almost always voting in a block and usually winning 5-4 decisions when Justice Anthony Kennedy provides the swing vote. What is interesting is that Justice John Paul Stevens, appointed by Gerald Ford, a Republican, and Justice David Souter, appointed by George H. W. Bush, obviously a Republican, of the so-called liberal justices of today were not considered activist or liberal when they were appointed, but have moved in that direction compared to the extremely constructionist justices that have been appointed since. Now, one thing is clear. A judge is human and carries baggage of personal, political, and social bias. Judges no doubt strive for objectivity, and we attempt to protect their independence, but individuals' ethics clearly are an important consideration in any judicial discussion. The law is subject to interpretation, thus individual ethics plays a part in the use of powers given to the judiciary. Now please continue with this week's assignments.